David Richmond. I'll be presiding today. To my right is Judge Anthony Navarro. To my left is Judge Craig Welling. We have two cases on the docket today, People versus Orozco, and a case called GKK Works KIP versus 3330 Brighton Boulevard. Counsel are present for the first case, I see. Are counsel present for the second case as well?
Yes, Your Honor.
Great, then I won't have to repeat the instructions. I think all of you counsel are experienced. You know you have 15 minutes per side to argue your case. The appellant may reserve time. If the appellant wishes to do so, there's a clock on the podium. You're responsible for sitting down whenever you want to sit down. If you want to reserve time, we're not going to wave a yellow flag or anything like that. Please stay close to the podium, because these proceedings are being recorded and I think live streamed. And if anybody in the audience has any cell phones or devices that would beep, please turn them off so as to not disturb the arguments. And if there are no further questions, counsel may proceed. Appellant in the first case, People versus Orozco.
Good morning. May it please the court. I'm Anthony Noble, registration number 33910, and I represent the appellant, Patrick Orozco. The main issue in this case is whether Mr. Orozco was denied his right to counsel of choice, his right to waive conflict-free counsel, and his right to the first impanel jury when the district court disqualified his public defenders and then declared a mistrial. What happened here was, midway through trial, it became, one of the deputies became aware that someone in the audience was taking pictures of the trial. And this led to a bench conference and a series of arguments in which the court ultimately determined that the public defender should be disqualified, and then ADC was appointed, and then the court declared a mistrial. So the main question before the court is whether or not there was a conflict of interest that required disqualification of the public defenders and then a declaration of a mistrial.
Now, why, given the trial court's findings about both the nature of the conflict and then the description of why the public defender was concerned, and then the trial court's observations of how it impacted his performance, because there were some findings made that he was less than robust in his courtroom demeanor based on the trial court's experience with him in other cases. Why is that conflict? Why would that conflict have been waivable at all?
Well, Your Honor, I think there's only one type of conflict that's not waivable, and that's set forth in the Rules of Professional Conduct. So, for instance, I think it's 1.7b, which is the waiver of a conflict of interest. And the kind of conflict that is not waivable is when defense counsel is representing two parties in the same litigation in adverse positions where one party has a claim against another. So I'm not aware of any case law that says that any other kind of conflict is not waivable. Now, this kind of conflict that occurred here, it's not even a concurrent representation type of conflict. It's the attorney's personal interest. If it could be even framed as that, essentially the attorney was afraid that the photographs had been taken by the victim's sister.
Why would you say that that's questionable as to whether or not the conflict is based on a personal concern? I mean, he expressed those concerns about his own safety, expressed the concerns about the gang ties between the victim and concerns for his own safety based on having been the subject of the photograph. So I mean, how does that not, without pretty clearly, raise a personal conflict of interest? I mean, whether it's waivable or not is a different question. But why do you raise the concern as to whether or not that's even a personal conflict?
Well, Your Honor, when you look at the case law on personal interests of attorneys, most of the cases are addressing financial interests of attorneys and determining that there may be a conflict based on a personal interest because of financial interest of the attorney. Now, there are, maybe, well, I found at least one case.
And this was do you agree this was a safety interest? You don't dispute that the counsel's concern for his safety, the safety of others on his team, or maybe even the safety of the juries, was a legitimate concern. You're not saying that he fabricated that, are you?
No, no, of course
Okay.
not. No, I'm not saying he's fabricated it.
Right.
Clearly he was afraid.
And he also indicated that, being afraid, he didn't feel he could continue to represent your client effectively. He didn't use those exact words, but certainly he conveyed that to the court, right?
That's correct.
Okay.
And
And the
so
judge found if you can't represent this client effectively, that by definition is a conflict of interest. And I think that's what Judge Welling is getting at. You don't disagree with that?
No, I don't disagree with
Okay.
that. What I disagree with was the way that the court approached this potential conflict of interest, because we have clear guidance from the Supreme Court on how a court should determine whether or not to disqualify a defendant's attorney. And
You say potential, and I'm sorry for interrupting,
Yes.
but isn't it an actual conflict of interest here, as
Well-
opposed to a potential conflict of interest?
why would it be an actual conflict of interest?
Because the lawyer has expressed a concern for his own safety and the ability to continue the representation. So he has expressed his own personal interest, his intention with his obligation to zealously represent his client. Why isn't that an actual conflict as opposed to a mere potential conflict?
Because here, the attorney is expressing his fear, really, and his fear, ultimately didn't play out to any kind of threat, because I think that there may be an actual conflict of interest. If there was a death threat against the attorney, then I think he'd be put in the position where he could really not represent the defendant. But that's not the factual situation here. I mean, there were no death threats here. It was a picture taken by the victim's sister, and it was distributed to 3 or 4 people. Now, the deputy caught it pretty quickly, and the victim spoke to the judge, and the first thing she did was apologize for what she had done.
But there was an evolving narrative around who was sent those pictures. I mean, it's not as though snapped a picture, I'm sorry, this is the only person I sent it to, we'll erase it. It kept changing and expanding as far as who was being photographed, as well as the number of people that it was distributed to in the course of a relatively short period of time, which added to the concern that this had a potential threatening element to it, as opposed to just an innocent use of a cell phone in an environment where it shouldn't be used.
Yes, and it was evolving during that afternoon of trial. And then ultimately what it came to was the fact that 3 or 4 people, actually 3 people may have received the picture. One of them was also the victim's brother, who was present in the courtroom, and he also cooperated with the judge and with the police in the same way that the victim's sister did. There may have been the victim's daughter. I think the victim's sister's daughter was also sent a copy of the picture, and the court ordered her to come into court. And I don't think there are really any issues around her non-compliance. But what happened here was that all the people that had received the pictures had cooperated with the police. The police seized the phones. They looked at the phones. They were very apologetic. And then ultimately, the police investigation didn't result in any kind of prosecution or any kind of evidence of any threat, let alone a death threat. So this really is a potential conflict of interest. And I think if you look at it from the other side, I mean, would you reverse a conviction based on this kind of conflict of interest if the court had continued with the trial and there was this very potential conflict of interest?
I'll turn the question around. Would you file a Rule 35C or an appeal to say this guy had ineffective assistance because he was laboring under a death threat? You might not, but another attorney might have. And isn't that the dilemma that this judge was facing? If I let the trial go forward and this man is convicted and his lawyer has had this, I'm going to call it a threat or a fear for his safety, let's call it that. If he fears for his safety and represents him, he'll have grounds to file an appeal or a Rule 35 motion. The judge said that on the record. If I let it go forward, the safest thing to do, the most economical thing to do, is terminate it right now. Get him a new disqualified lawyer, get him a new lawyer, see what that lawyer wants to do. We could continue if that lawyer wants to continue, but of course he wasn't prepared.
And it'd be a particularly strong 35C because this is similar to the facts in Rodriguez or what they discussed there. It's a question of what did the lawyer not do because he was laboring under this personal conflict. Therefore, the ability to show that there's no need to show prejudice if you can establish an actual conflict. So this would be had he stayed on board, it's a pretty strong 35C, isn't it?
It wouldn't be successful, though. Now, and the thing is coming back to your question about, whether or not this would create a 35C claim, there's going to be post-conviction proceedings in every single first-degree murder case, period. And the Supreme Court has specifically said that that should not really be the court's concern about future litigation. I mean, the court has to be concerned with the defendant's constitutional rights. And here, the defendant's constitutional right to his presumed counsel of choice, his constitutional right to waive conflict-free counsel, and his constitutional right to the first impaneled jury are really what trumps everything else.
But there's a third factor, and that's the fairness of the proceedings, right?
Yes.
In Rodriguez, there's 3 factors identified.
Yeah.
So if the judge weighs those 3 factors, and he decides that the fairness of the proceeding is more important than his choice of counsel, that's a choice that he could make, isn't it?
Yeah, but he never weighed the factors. So that's the real problem here, is that he was presented with this request to be disqualified, and then it's clear from the Supreme Court that there are 3 factors that have to be weighed. The court didn't weigh them.
Which one are you saying he did not consider?
Sorry?
Which did he not consider?
The first one, which is the most important
Okay,
factor,
but
which
if
is...
all right, so let's go back to that. That's where we
Yes.
started. Your position, as I understand it, is that no conflict, every conflict is waivable other than the conflict of, I think you said, multiple representation.
Joint representation of two clients with
Right.
opposing interests in the same litigation under 1.7.
But surely there are other cases, U.S. versus Wheat.
Yeah, and there
Can't-
probably are, but
That was
that's...
a non-waivable conflict.
Yeah, that
People
probably...
versus Curran, Judge Roy there said there were non-waivable conflicts. There are other non-waivable conflicts, aren't there?
Yeah, but this was a waivable conflict.
And why is that?
Because first, it wasn't concurrent representation.
No, that's
And-
not the issue.
Yeah.
But I guess what I'm asking you is whether you want us to say that a threat, a genuine and objective fear for the counsel's own safety is a waivable conflict. That's the position you want us to take to start this case, to start our analysis.
That's correct, Your Honor.
Okay, and if we
Yes.
conclude that it's a non-waivable conflict, that is, the defendant can't waive his counsel's fear of his own safety, you're saying that's an improper resolution of this case?
Well, I think, yes, Your Honor, that the big question here is whether or not the conflict was waivable and non-waivable. If it's a non-waivable conflict, then there was harmless error. But this was not a non-waivable conflict, and the court was required to go through the balancing test to determine whether or not to disqualify counsel.
Can you?
Counsel? Oh, sorry. I mean, on the question of whether this conflict is waivable, is that committed to the trial court's discretion?
Well, I think that when you look at Rodriguez and Harlan and Nozzolino, what the Supreme Court has instructed is that to determine whether or not to disqualify counsel based on a conflict of interest and to determine whether or not a waiver is permissible, then the court has to go through the 3-part test. So there is an element there of discretion. So yes, the court does have discretion after conducting the 3-part balancing test to determine whether or not to disqualify counsel based on the conflict of interest or to allow the defendant to waive the conflict. So the big problem here is that the court didn't go through the analysis that it was supposed to go through. So we don't know whether or not, there was no exercise of discretion. So that in itself is an abuse of discretion.
Before disqualifying, or before declaring a mistrial, the court appointed conflict-free counsel and allowed that, took a break, allowed conflict-free counsel to advise his client, and then conflict-free counsel moved for the mistrial. So even if it was an erroneous disqualification, or he still had conflict-free counsel who moved for the mistrial. Why doesn't that end our inquiry? The fact that, because he did not rule on the public defender's motion for a mistrial. He basically said, no, we're going to put a pin in that. I'm going to get him conflict-free counsel. Conflict-free counsel made that motion for a mistrial, saying I can't proceed. Why isn't that sufficient to protect his interests?
Well, first, Your Honor, the trial judge did say that he was going to grant a mistrial anyway. And then once he did disqualify the public defenders, there's no attorney in the state or no attorney in the country that could pick up a first-degree murder case that afternoon and continue with it. So the only choice that counsel could make, that the ADC attorney, was to move for a mistrial. And then ultimately, the trial was scheduled 3 months out, and the attorney still wasn't prepared to go to trial after 3 months of preparation. So really, the decision regarding the mistrial was made well before ADC was appointed to represent the defendant.
But that
So-
was his conflict-free attorney's motion. And the attorney with a conflict did not have his motion for a mistrial ruled on by the court, right? I mean, I'm reading the transcript, right?
That's correct. I mean, the court did reserve ruling, with the caveat that the trial judge said that he would grant a mistrial. So by the time ADC was appointed, then there was no decision that could be made other than to ask for a mistrial, unless the court has any further
I
questions.
do have one. Can you
Okay.
point us to any authority that says when counsel is laboring under a fear of his own safety, that is a waivable conflict? Can you point us to any authority in Colorado that says that?
No, I don't think there's any authority either way that it's waivable or
Okay.
non-waivable.
How about out-of-state authority? Have you looked at
Not
any
that I'm-
out-of-state case to say that it's not it is a waivable conflict when counsel's laboring under fear of his own safety?
Not that I'm aware of. And I think that the whole purpose of having this test in Rodriguez, Holland, and Nozzolino is that test itself determines whether or not there's a conflict of interest and whether or not the defendant can waive the conflict of interest.
Okay.
Thank you.
Thank you, counsel. I think you might have 10 seconds left, but I'm not sure.
May it please the court. My name is Erin Grundy, registration number 41271, and I represent the people of the state of Colorado. Nothing undermines the integrity of the judicial process more than threats on the participants in that process. In this case, the trial court admirably handled an evolving situation in order to protect the defendant's right to conflict-free and effective counsel. What it did in this very stressful and hectic circumstance is exactly what the rules of professional conduct and case law encourages courts to do. The moment the court was notified of the potential conflict, it assessed with counsel, it handled the situation, it allowed all parties to make a record, and while there are things that maybe in hindsight the court could have done differently, we address conflicts at the time when things are evolving, in the murkier pre-trial context when everything is still shifting and unfolding. And that's where we assess the trial court's discretion in the rulings that it makes. Here, it was faced with a situation where the public defender presented the court with the idea that it could no longer represent the defendant. And under Rule of Professional Conduct 1.7, a lawyer shall not represent a client if it involves a concurrent conflict of interest. And a concurrent conflict of interest exists if there's a significant risk that the representation of one or more clients will be materially limited by the lawyer's own interests. In this case, the record shows that the lawyer's interests did materially limit his representation of Mr. Orozco. The court noted that he was observably afraid, was clearly not representing in the way that counsel normally did, that he had to take breaks. We see that counsel specifically says on the record, "I'm afraid for my safety. I'm afraid for the safety of co-counsel. I'm afraid for the safety of the advisory witness," and also alerts the court of concern for safety for the members of the jury. And the court respects that. The court makes specific findings that counsel is credible, that it's an objectively reasonable fear, particularly given the gang ties at play in this case, and that the victim was a relatively serious member of a rival gang of the defendant. We know that there had been some threats on the internet that one of the witnesses testified to. Now, the threats that the witness specifies were directed towards the defendant, but we also know that this is an evolving situation. The court says, I know that there were threats on the internet and there was some testimony to that, but doesn't go into the extent. But the court is aware of actually looking at the parties. It can assess credibility by the shaking, by the fear, by the pause in voice, and by the way the trial is proceeding, and tell that the concurrent conflict of interest is actually inhibiting effective, conflict-free representation that the defendant is constitutionally entitled to.
So accepting your position that this defense team was labored under a conflict, I think it's a position of the defendant that at that point, the judge should have expressly asked the defendant, do you want to go ahead with this lawyer, or do you want me to get you somebody else, in effect? And the defendant is saying the judge didn't do that. Is that the first step of Rodriguez, and did the judge omit to comply with that first step of Rodriguez?
The defendant's choice is one of the factors of Rodriguez, and I agree that it is the first step, but that's not necessarily shown by a personal on-the-record inquiry like we look at under Curtis or Arguello. Rodriguez certainly doesn't specify that that is the procedure that the court needs to take, and that we need that type of inquiry, because this isn't something where it's the right to testify or the right to remain silent, the right to counsel, the right to recede pro se, where the defendant's choice is absolute and nothing else can override it. So I agree it may have been better practice to personally inquire of the defendant.
Was
And
this,
actually, oh, sorry, go ahead.
was this a waivable conflict?
Absolute. This was not a waivable conflict.
Non-waivable conflict.
This was a non-waivable conflict.
You guys are 180 degrees different, I think, on that point, right?
We are, and I
Do you
think,
have any authority? I asked him, I asked the same question. Is there any authority that says counsel I know this seems kind of obvious, but I haven't found the case. Counsel laboring under a fear of safety for himself or others, the jury, whatever, has a non-waivable conflict of interest. Have you found any case law that says that?
Your
In
Honor-
the state or outside the state?
Your Honor, I didn't. What I did find, and I cited in the brief, was the two cases that refer to judicial recusal, which I think is at least somewhat analogous. The Nichols case out of the 10th Circuit and the Euling case out of the 2nd Circuit, which I think also say where there's a credible fear of safety. In Nichols, it was obviously the Oklahoma City bombing,
For the
which
judge.
Right. So I think in that context, one of the things also the Southern District, I think it's Florida case, says where a reasonable man on the street would think this person can't possibly be fair, then recusal is warranted. I think that's analogous in this context, where when counsel's laboring under an actual conflict of interest, where they're clearly basically shaking in their shoes, showing that they can't be fair, then that's a non-waivable conflict. I think we can also look to Rule of Professional Conduct 1.7b, which only allows waiver of a conflict if the lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation. So I'm not saying necessarily that personal interest is a per se class of cases that are non-waivable, but that this particular conflict was non-waivable because there was no way to fulfill the condition precedent in 1.7b that the lawyer be able to provide competent and diligent representation. If anything, the record shows the complete opposite of that, not only through the court's observations of how counsel is actually acting in the case, that he's afraid, that he has to pause, that he can't continue in the case, that he's certainly not performing to the level of his experience that the court has observed, but also because the lawyer is subjectively and objectively stating, I cannot continue. That alone should be enough. When we know that we cannot...
Did the lawyer say, I cannot continue, or I have a conflict? Now, because the inquiry wasn't made either of the defendant as to whether or not he wished to waive that conflict, or of the lawyer as to whether, knowing that your client wishes to waive this, and presumably it's one step beyond what we do in Curtis, which what the defendant's asking for is he was entitled to conflict-free counsel to advise him on the issue of whether or not to disqualify his lawyer. But if he had asserted that right, then the inquiry would have needed to be made of the lawyer of whether, knowing that your client wants you to continue to represent him, can you ethically do it? And so there's a difference between the lawyer alerting the court that I think I have a conflict versus alerting the court that I will ethically be unable to represent my client, isn't there?
Here, and I think there can be. I think in this case, we cross closer to I can't ethically represent my client. And we know there are also some discussions in chambers that the court references where the court comes back on the record and says, I am going to note his distress. I'm going to not repeat everything that was said, but I find it objectively reasons for concerns. So I think what the court had at the time also certainly suggests that the court was very concerned that this was an actual conflict of interest and the lawyer could not continue. I agree he didn't use those specific words, but I think that had the defendant spoken up, had the defendant filed pro se motions at some point, or had the defendant, through counsel, stated that he wished to retain counsel, all of those could have triggered the court needing to inquire further. But of course, none of that happened. Now, even in Harlan, we see that. In Nazzolino, we see that. And it's not necessarily prompted by the court. It's often the defendant saying, I don't want my counsel to withdraw. But none of that happened. So it didn't trigger that on-the-record inquiry under Rodriguez. But even if it had, The other two Rodriguez factors absolutely weighed in favor of withdrawal and substitution of counsel. First and foremost, being the strong interest in permitting withdrawal in order to maintain the integrity of the judicial process. Nazzolino tells us that we want trials to be conducted in an even-handed manner and to protect the parties from unfair tactics. But the inherent component of this is that the defendant is first and foremost entitled to a fair trial. And we won't know what would have happened had counsel continued. Had counsel been afraid that his life would be threatened, had he continued to effectively represent this defendant. I think this absolutely would have raised concerns for the 35C claim that Judge Welling raised, and I dispute that it would not have been successful. Now, when counsel says, I am afraid for my life, the actual prejudice shown is something that we can really only speculate. But we certainly would have concerns if counsel didn't thoroughly cross-examine certain witnesses. If any of that had happened, that might suggest that defense counsel was not acting to his fullest ability to protect the defendant's constitutional rights. All of those could have been concerns, and they were all certainly things for the court to consider. I also think when you look at the integrity of the judicial process, you also need to look at the objective situation that the court was faced with, which is that counsel cannot reasonably be expected to continue. Now, this counsel was experienced. He'd been with the public defender system for a long time. Presumably, he'd been through a lot of different things that arise during trial. But expecting counsel for defense, counsel for anyone, to have to continue when they feel that they cannot because of their own safety concerns, it's not reasonable. That doesn't protect the integrity of the judicial process, and it also doesn't ensure that the defendant's constitutional rights to a fair trial with conflict-free, effective counsel are secured.
Ms. Grundy? Go ahead. Could you talk to me more about why the court decided that the entire office was conflicted? Because that's where the reasoning sort of breaks down for me, and there seemed to be very little actual explanation for why the entire office would be disqualified when the photos at issue were obviously of just this one attorney. And the court was able to appoint a different defense counsel, ADC, so it's not as if no defense counsel could ever represent this defendant. So why couldn't other members of the public defender's office have stepped in?
Here, the court was focusing primarily on the close-knit nature of the public defender's office, that it was aware that defense counsel had clearly had to bring this up to supervisors because supervisors were actually present at the September 3rd, 2015 moment where counsel was disqualified. The court was very concerned that the close-knit nature of the public defender's office would force this public defender to explain why he was afraid.
And so what? Why is that a problem, that he has to explain what he thinks?
Well, Your Honor, I think it's one of the things that trial courts can consider in exercising their discretion. I don't know that this is a situation that required disqualification of the entire public defender's office, but it also wasn't an abuse of discretion to do so. The trial court was more familiar with the El Paso County Public Defender's Office, was more familiar with this public defender and specifically referenced the reputation of this public defender, and was also concerned about the potential to become a witness in the trial. Now, I agree with defense counsel that the sister was not an endorsed witness, and I don't believe she testified in the second trial, but we don't know which witness that the court was referring to. Certainly the witness who testified regarding the threats did testify in the second trial. It could have been that witness, it could have been someone else, and it may also have simply been that it was an evolving situation, and the court didn't know and couldn't reasonably have known how it would unfold. So I think the court properly exercised its discretion in disqualifying the office, even if it wasn't necessarily required to.
And had the court not disqualified the entire office, but only disqualified the lawyers on that case, his right to have the impaneled jury would not have changed. I mean, we'll appoint a new public defender. You're still not going to be able to go forward with a first-degree murder case with a new member of the office. It would have, as a practical matter, required a mistrial and a retrial with being represented by somebody else in the office, right?
Absolutely, and at least as long of a continuance. I think it's actually more likely than not that the continuance may have been longer given the even heavier caseload of the public defender system, especially if they had to bring someone in from another office. I think it also raises an interesting question under Gonzalez-Lopez, where we know that an indigent defendant has a right to counsel of choice once that counsel has been appointed for him. but not a right to choose counsel prior to that appointment. So here, the defendant's right to have free and effective representation appointed to him was satisfied. And he doesn't have a right to choose a particular counsel or even necessarily a particular office. Often when trial judges disqualify a public defender for reasons such as a breakdown in communication, ADC is who is appointed, and I've not seen that be challenged in this context where you have a right to continued representation by the public defender's office. In Nazzolino, Mr. Nazzolino referenced that he would like to continue with the public defender, but it was in a very different context where he wanted to retain the actual public defenders who had been representing him. So I think there's also a question of whether there was even a constitutional right at play to maintain the public defender's office rather than simply appointment for the indigent defendant by competent and effective representation who was able to proceed on this F1 trial, which Mr. Anaya from ADC certainly was, to the extent that we can see there have been no appellate claims raised from that second trial. Turning briefly to the mistrial, our position is simply that the defendant requested this mistrial and that becomes a waiver under 18-1. You look like you have a question,
The
Judge.
defendant was present when Mr. Oneida requested the mistrial, and the record does, he says on the record, I consulted with my client before that.
That's
The record
right.
also shows, I think, that Mr. Roscoe was present when the trial judge disqualified the public defender. In both instances, he didn't say anything. The record, he didn't say anything. He didn't object to either of those activities. Here's my question. Do we know that Mr. Roscoe's understood the proceedings? Is he an English speaker?
Your Honor, I don't know the answer to that. He certainly does in the second trial. He does have an on-the-record discussion with the court where he says, "How are you? I'm good," and that's on, I believe, the
Okay.
April 6th transcript, but I don't know if that was through an interpreter.
Okay.
Thank you.
Thank you. Thank you, counsel. I guess you have a few seconds.
There is some guidance on whether or not a conflict of interest is waivable in 1.7b. And part of that rule that the Attorney General refers to is the first part, but she only alerted the court to the first part of that sentence. The full sentence says that the lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client. So that's not something that can defeat a waiver. And with that, I'd ask the court to vacate the first-degree murder conviction.
Thank you, counsel.
Thank you, Your Honor.
Thanks to both counsel for your arguments. This case will stand submitted. An order will issue in due course. We'll now turn our attention to the second case on the docket, GKK Works KIP versus 3330 Brighton Boulevard. You may proceed, counsel.
Thank you. May it please the court. Chris Dawes for the appellant, 3330 Brighton Boulevard, LLC. With me at counsel table is my colleague, Risa Brown. Your Honors, I will cut right to the chase. This case is about contract interpretation. We have a provision in a settlement agreement that talks about paying $380,000 as payment in full. Payment in full. That includes all prior requests for equitable adjustments. It includes that amount. And that is to settle all services performed, incurred by the architect and its consultants through July 9, 2017, in exchange for a waiver and a release of all claims against the owner for compensation due to architect and its consultants through July 2017. When it came time to perform here, GKK said that's not what it really meant. It means something fundamentally different. GKK suggests that the agreement really didn't cover all services. It covered only certain services. That's not what the agreement says. The agreement says all services, and that includes equitable adjustments. So one of the things we look at here,
Well, it says including all prior requests for equitable adjustments, comma.
correct,
So including, sometimes the including means including but not limited to, or including means only including, or all, totally including, but it doesn't say, it doesn't say that here.
it does not say, I think that the issue you raise, Your Honor, is that including does not limit the provision to simply equitable adjustments. I think when you look at it, including is not a restrictive term, as GKK would argue in this case. And again, I think when you look at when you look at the remainder of the provision in this paragraph, it makes clear that the architect is going to deliver to owner mechanics lien waivers for itself and its consultants effective through July 9, 2017. It's a release of all claims
Well,
against
it
owner.
doesn't say all, its consultant, it says, first of all, it doesn't say its, there's a typo here, I think, right? Doesn't say for itself and it consultants? Is there a typo there?
It does.
Yeah, okay, so it says, and it consultants, so it doesn't say it's all its consultants, right?
It does not use the word all its
And
consultants.
there were, I know there were two at issue in the mediation, but there were more than two on the project. So that was one of the ambiguities that the judge picked up or found in the document. So how do we address that?
So I think how you address that is, again, going back to the language about the waiver, that payment is in exchange for the architect's waiver and release of all claims against owner for compensation due to architect and its consultants through July 9, 2017. It doesn't say again, it's all claims is what's referred to in terms of being released for compensation. It's not any particular type of compensation. It's any compensation. It's not as limited as GKK would argue in this case. And I think when you also go forward and you look at, Your Honor, when it talks about architect and its consultants, it's not limited in any way, shape, or form. It doesn't say it's two consultants. It doesn't say a handful of the consultants who were involved. GKK wishes to read in a limitation there that's simply not there. When it says GKK and its consultants, it can only fairly be said to mean all of its consultants, notwithstanding the word all is not placed there.
Now, I know we're not supposed to look at extrinsic evidence, but this was drafted by the mediator, not by you and not by your opposing counsel. Part of the problem here, I suppose. The mediator only was involved with two of the consultants, right? He didn't have any contact, or I don't know, contact's not the right word, but he didn't have any involvement with the other 7 or so consultants, did he?
Well, and frankly, on the record, it's not clear the mediator had any involvement with any of the
Any
consultants.
consultants.
Okay, so, and all those contract claims flow through GKK up to the owner.
I guess
So-
my only point is that to the extent that a mediator might have known of consultants, he knew of 2 of them, but he might not have known of the other 7.
I don't think there's anything in the record that
Okay.
would support that the mediator was only aware of 2 of the 7. And I would, and again, because we have limitations on the extrinsic evidence that should have been considered, I'm not going to go into what was actually discussed at the mediation.
Let me take you on another course. Really, I'll try to be brief. I believe you argue in your brief that the judge considered extrinsic evidence in deciding whether or not this document was ambiguous, correct?
Oh, I think that's in our argument. I think that's
Okay.
certainly implicit in our argument.
All right. But
And I think,
when I read his order, if you read his order very carefully, if you look at his order, He reaches a conclusion that this contract was ambiguous by the end of page 4 of his order, and at that point in his order, he never mentioned any of the extrinsic evidence. He doesn't talk about that until he later goes into this meaning of the minds analysis. So I take issue, I don't see why you might be saying that his order considered extrinsic evidence in deciding whether this document was ambiguous.
Well, I think when you look at the transcript, the court was very focused on extrinsic evidence and very much put the cart before the horse at this hearing, in hearing all the extrinsic evidence before making a determination as to whether the contract is ambiguous or not.
Well, but he
So-
had to consider the extrinsic, I mean, this was a single trial to both determine whether the contract was ambiguous, and if so, whether there was a meeting of the minds. So it wasn't a bifurcated proceeding. So he needed to take all of the extrinsic evidence, because if it was determined to be ambiguous, then he needed to consider that in order to determine whether there was a meeting of the minds, right?
Well, no, I don't agree with that analysis. What I would say is, what GKK does in its briefing is it suggests that the standard review we're really here on is one to determine whether there in fact was a contract. Was there a contract in play where we first look at the four corners of the document to determine whether there's an ambiguity? And I think that's the fundamental flaw that happened below, is the court didn't look at the agreement first to see if there was an ambiguity at all. So the court's entire view and take on this contract was improperly colored by considering all this extrinsic evidence at the front end over, frankly, my objection to that issue,
Well, I mean,
requesting that determination.
Judge Richmond can defend his own question, but I think that was the point of his question, is that if you really look at the court's order, it focuses on the contract itself in making the determination of ambiguity, and relies on the extrinsic evidence for a determination of whether there was a meeting of the minds once that ambiguity determination based upon the language used in the contract is resolved by him. And I think that's the point of this inquiry and the work that the extrinsic evidence was really doing here.
Again, I go back to, we have a fully, and there's an issue of whether, is it a fully negotiated document? I would say, in a sense, it is. We went through a whole mediation. The mediator prepared a contract. And so what the court's inquiry should be focused on, first and foremost, is the four corners of the agreement to see if there's an ambiguity. And I would go back to where we started, Justice Richmond, which when you go through and you look at the contract, I really don't think you can read paragraph 3 any other way than as advocated by the owner in this case. Again, when you talk about on the front side, what is the payment for? It's a payment in full for all services performed and reimbursable expenses incurred by the architect and the consultants. And then when you look at the flip side, of what is being paid, the waiver and release, again, is all claims against owner for compensation due to the architect and its consultants through July 9, 2017. So I think when you read those two together, you can't help but come to one conclusion, which is all the claims for compensation are covered by this settlement agreement. There's not a carve-out as to particular types. Had it been the intent for it to read that way, it could have said, it's going to resolve all claims for base services or all claims for equitable adjustment. It doesn't say any of those things. It says all compensation for all services.
Is the linchpin to your argument that the contract is unambiguous? I mean, if you don't persuade us that the contract was unambiguous and should be read in your direction, does everything, do you have a leg left to stand on?
Well, I think so. To be sure, the thrust of our argument is it's an unambiguous contract that should be interpreted on a de novo standard. We think it reads the way we've advocated. However, that being said,
okay.
I mean, there is parole evidence. When you look at 2 weeks after the settlement agreement was done, there is a letter that comes into my office that says we're prepared to deliver lien waivers for GKK and its consultants, including 2 of the sub-consultants, which suggests that GKK's counsel itself was reading that expansively to include all the sub-consultants at that time, at least 2 weeks after the mediation. So I think there is that issue.
Mr. Dawes, on that issue, I did not read your brief to be challenging the trial court's factual finding as to the meaning of the agreement. Your brief rests entirely on the notion, as Judge Welling said, that the document is not ambiguous. I don't think you went on to discuss what we should decide if we disagree with you about the document being ambiguous.
Oh, I think, to be sure, if the document is found to be unambiguous,
Then you win an interview. But what if we disagree with that? I didn't see anything in your brief addressing the situation where we disagree with you and instead we find that the document is ambiguous.
right, and if you find the document is ambiguous, then you would look to the record testimony. Of course, it's a different standard of review.
Right,
but-
and I didn't see you challenging the trial court's factual findings on that question.
Well, again, one of the things I would point to, and is pointed out in our briefing, is that with respect to the delivery of those lien waivers, GKK itself was reading the agreement to require lien waivers, not only from GKK, but its consultants, including two in particular. Again, nowhere in the document is the lien waiver delivery requirement so limited.
So that seems to be an argument that the trial court was wrong as a factual matter in determining the intent behind the agreement. And I didn't see that argument in your briefs.
Well, I think that's certainly implicit in the argument at a minimum that we pointed that issue out. But again, first and foremost, I think it's an unambiguous document. With that, I'd like to reserve the rest of my time.
Okay, thank you,
Thank you.
Counsel.
Good morning, and may it please the court. I'm Michael Cowan, bar number 52081, and I'm here today on behalf of the appellee GKK Works/Clip Inc. The trial court's admission of extrinsic evidence was appropriate in this case for three reasons. First, extrinsic evidence is admissible under Colorado law to determine if the parties reached a binding agreement. Second, courts may conditionally admit extrinsic evidence to determine whether the agreement is ambiguous or not. And three, here, extrinsic evidence was also admissible because the agreement is ambiguous. And the trial court not only had a legal basis for admitting extrinsic evidence, this is exactly the type of case where extrinsic evidence should have been admitted. Contract formation was an issue in this case. The parties did not draft the agreement. The parties did not discuss the terms of the agreement, and the parties had no face-to-face negotiations of any of the terms of the agreement. At the time the parties attempted to perform under the agreement, it became clear that both parties had materially different understandings of the claims to be resolved by the document.
You started the lawsuit, didn't you?
We did, Your Honor.
You're the plaintiff. This really threw me. You're the plaintiff. What were you asking for? A declaration that this was not an agreement? An interpretation of it in accordance with your, I mean, you guys started it. Yeah, you're defending. I'm a little confused.
Yes, Your Honor. At the time of initiating the action, we believed that the terms of the agreement were consistent with our understanding of the document.
Therefore, there was an agreement.
Well,
Now you're telling us there was no agreement for him, but that's not what you said in the district court. When you filed your complaint, you said there is an agreement and it means what we say it means.
it was only after the suit was initiated that it became clear to us that there was no meeting of the minds and that the owner had a materially different understanding of what claims were involved in the purported settlement agreement, Your Honor.
Did you withdraw your motion to enforce the agreement at that point?
I don't believe so, but by the time we got to trial, that was the primary argument advanced by GKK, was that there was no meeting of the minds and that that was a threshold issue that had to be addressed prior to getting to any contract interpretation type issues.
See, I think I read their closing arguments differently. Your first request was enforce the agreement as we see it, and that was in your closing at the end of trial. That was your first request, and then you said, alternatively, if you don't grant our first and primary request, then fine, there's no agreement at all. Isn't that what happened?
Oh, I believe that's correct, Your Honor. However, in the trial court's approach to the issues presented, we believe that the court was correct in first, or excuse me, not maybe first, but in also considering whether this was an issue of contract formation, as which was the ultimate holding in this case, is that there was never a meeting of the minds. And so the court, of course, denied our motion as well as the counter motion to enforce against GKK Works. So it's sort of an interesting a situation where we did seek to enforce the agreement, but by the time we got to trial, it became clear to GKK Works that whether the parties had a mutual understanding of all of the essential terms was clearly a question in this case. And the trial court was also correct in admitting extrinsic evidence here, particularly because contract formation was an issue. Trial courts may admit extrinsic evidence to make that factual determination of whether the parties had a mutual assent to the agreement. This case is very similar to the famous British case, Raffles versus Wickelhaus, which is discussed in Scholes versus Cleobold that we cite in our brief. And
Ex-rel Peerless. The ship Ex-rel Peerless.
Exactly, Your Honor. In that particular case, two parties entered a contract for the purchase of goods aboard a ship called the Peerless. After entering the contract, the parties realized that there were actually two ships named the Peerless and that the purchaser had intended to buy the goods aboard the other Peerless. Of course, to get to that point, the court had to admit extrinsic evidence to determine that there were two ships and from which ship the buyer had intended to purchase the goods. Under those circumstances, the court found that there was no mutual assent to the essential terms of the agreement and therefore no enforceable contract. The same applies equally here as to the known claims that the document was intended to resolve. The owner, as one of the parties seeking to enforce the agreement, had the burden of proof to prove all terms of an enforceable contract, including mutual assent. Of course, the trial court found that the owner did not meet that burden because he found that there was no meeting of the minds.
Counsel, what is your response to your opposing counsel's point that the cases, at least from this country, that you rely on the contract formation issue, don't deal with the signed written contract? They're trying to figure out whether a contract exists either through conduct or oral statements.
Sure. Well, I would say a couple of things, Your Honor. First, the cases that we rely on talk to general principles of contract law that apply regardless of whether it's a written contract or an oral agreement. The rules would apply equally. Second, we do cite to some cases involve signed documents such as Scholes versus Cleobold and IMA versus Rocky Mountain Airways. Of course, there's also other cases in Colorado that address signed documents where the courts have found no meeting of the minds. For instance, in Jorgensen versus Colorado Rural Properties, 226 Pacific 3rd, 1255, that case involved an employment agreement between real estate agents and a brokerage, and in that agreement, it talked about splitting of commissions. After entering the agreement, a dispute arose between what that provision meant. The trial court found that there was no meeting of the minds as to that essential term, and on appeal, the Court of Appeals noted, citing Yackel, that a determination of whether a contract exists is a factual determination that the court would not overturn unless it was clearly erroneous. The Court of Appeals then determined that there was factual support in the record for that determination and affirmed, and the trial court's ruling here is consistent with that opinion. And I'd also like to turn to a couple of other arguments that the owner has raised on appeal. One being that the paragraph 3 of the agreement uses the phrase paid in full. I think that this argument ignores the fact that that's being referred to is being modified by the known claims. It's paid in full for known claims, which of course is where the parties have the material misunderstanding, and the document's ambiguous on that point, and we can't look at the four corners of the document and understand truly what those claims were. Next, the owner also argues that the phrase known claims, disputes, and other matters in question is a mere recital that the court was entitled to ignore. The cases relied upon by the owner, first is Engineering Data versus Nova Office Furniture. And there the court provides that recitals and titles, not being strictly part of the contract, may not expand the terms of an agreement, but, and I quote, they may have a material influence on the construction of the instrument and the determination of the party's intent. All provisions of a contract must be considered together to determine, if possible, the intended meaning of the parties. The other case that the owner relies upon is Los Animas Consolidated Canal Company. And in that case, the court also expressly states, that recitals may have a material influence on the construction of the instrument and the determination of the intent of the parties. And moreover, these cases really deal with strictly contract interpretation, not contract formation, so I think that their application here is somewhat limited.
Your position is that the phrase "no one claims" is ambiguous.
I'm sorry, Your Honor?
Your position is that the phrase "no one claims" is ambiguous in the context of this document, right?
That's correct, Your Honor.
The judge said that, right?
I would agree with the trial court who, stated that, a person off the street, if they picked up this document and read that phrase, would have no idea of what claims were being
Let
resolved.
me direct your attention to paragraph 4, okay? This is the paragraph that outlined your client's obligations, right?
Correct.
Pay $150 and release all known claims, including all the owner's E&O claims identified on the attached list. And there's a several-page attached list.
Correct.
The owner was able to identify all the claims that he was making, or you were able to identify all the claims the owner was making against you, but the claims that the owner wanted to release against it were not specified in a list. Is there any explanation for that? How did that happen? How could that be? Wasn't there a list of all your requests for equitable adjustments?
I would say two things, Your Honor. One, the agreement was drafted by the mediator, and what was in the mediator's mind, we do not know. The other point, I would point back to the request for admission that GKK Works admitted. In that, it outlines the issues GKK Works submitted to mediation. Of course, it's not, as the trial court said, it's not dispositive of all of those issues, but that is evidence in the record of what issues were submitted to mediation, which does not include our base scope services or any, and it also, I would just like to point out that the owner takes the position that not only were base scope services included within this agreement, but also that amendments to the contract that were executed 3 days before mediation began also were alleviated the owner's obligation to pay for those services. The agreement doesn't make any mention of the base scope services or those amendments in the four corners of the document. Of course, this gets back to the heart of the issue of what were the known claims. Those issues were no longer, the amendments were no longer in dispute at that point. And as to the base scope services, those issues were never in dispute. And in fact, there's no evidence that those services had even been invoiced at that point. So I don't believe that they could even constitute a claim in the sense that would be applicable under these circumstances. And on the point of the request for mediation, my counsel opposite earlier stated that there's no evidence as to what its consultants met in the record. I would respectfully disagree with that. On GKK's request for mediation, attachment A, it specifically states that, and it uses the phrase, its consultants is KLNA and M&E Group. And so in a sense, for purposes of this mediation, it's almost as if we were defining its consultants as KLNA and ME Group. And so the evidence in the record is that the mediator was aware of those two consultants that GKK Works had defined as its consultants. So that is evidence in the record to that point, Your Honor.
That was what I was trying to suggest, counsel, that he only knew its consultants meant two, and that's what you're saying. There's a record to support that. But Judge Navarro has a question. Go ahead.
Go ahead, finish your question.
I'm done.
So there's evidence that perhaps the mediator knew of at least these two consultants, but we don't know if those were the only consultants because we don't know what happened during the mediation, right?
That's correct. Of course, this goes back to the trial court's findings of fact that this document could have been, its consultants could have meant just these two that were involved, and there was factual evidence in the record to support that, or as counsel opposite has argued that it meant all of its consultants. Of course, it doesn't say all of its consultants, and so I think that those are reasonable interpretations under the facts. And when you look to the surrounding facts, the trial court making a determination that it was just KLNA and M&A Group is supported by factual evidence. And I'd also like to just make one final point, Your Honors. The trial court also was correct in admitting extrinsic evidence in this case because it's admissible in under Colorado law to admit that contingently to make a determination of whether the agreement is ambiguous or not. In the trial court had that discretion to do that, and here on appeal, the real crux of what the opposing counsel is arguing is that the trial court's admission of evidence was inappropriate. Under Colorado law, it's hard to see how that could have been an abuse of discretion, given that for at least two reasons, extrinsic evidence was admissible in this particular case. One, to determine if the agreement was ambiguous, and two, to determine whether there was a meeting of the minds.
Do you, I want to go back to a question that Judge Richmond asked and that we discussed with your opposing counsel, and that's, did the trial court rely on the extrinsic evidence in making the determination of ambiguity, or did it rely on the contract? And what's your view on that?
I think if you look at the trial court's final order, Your Honor, he starts with looking at the four corners of the document and reaches the conclusion that there is an ambiguity before considering the extrinsic evidence. With that said, Your Honor, we would ask that the court affirm the trial court below.
Thank you, counsel. You have 2 minutes and 48 seconds for a rebuttal.
Thank you, Your Honor. One thing that I do want to point out is the IMA decision that counsel referenced. That's a case where we're not dealing with a written contract, but rather with an exchange of communications. And the court there considered extrinsic evidence in determining whether there was, in fact, going to be a contract. And that's one of the main cases relied upon by GKK. But in that opinion, where the court did allow extrinsic evidence, the court noted this rule should be distinguished from the one that applies when a court is construing an integrated final document established to be a contract. In the latter case, extrinsic evidence is not admissible to vary the meaning of an unambiguous document. So again, it goes back to kind of putting the cart before the horse in looking at the extrinsic evidence in this case and then getting into interpretation of the contract. And again, that was something we asked the trial court to do right at the front end of the case, which is look at the contract to make that determination.
Is this a fully integrated agreement?
I think it is a fully integrated agreement.
Was there a clause to that effect?
Oh, I don't think a fully integrated agreement needs to include an integration clause. I understand your point, and there's certainly plenty of contracts out there that are fully integrated agreements that don't include that clause. So yes, I think it covers the subject matter of what's within it.
And also what that case is talking about is varying the meaning of an unambiguous agreement, but that's distinct from determining whether or not a contract was formed, right?
And I think here too, there can be no doubt that a contract was formed. We have a writing with material terms signed by both parties. No one's contested the signatures or authenticity. We have a signed agreement. There's no dispute about that. What the court is then charged with doing is interpreting that language.
No, but for an agreement to form, it's not just whether or not we have a signed document with authorized individuals having affixed their signature. There still has to be a meeting of the minds, and that is a formation question, right?
Well, I think there's no dispute that the parties agreed to the content of what was in that agreement. And I think maybe the best evidence that GKK certainly thought there was a binding agreement is the fact that they moved to enforce that very agreement by filing this action. And I would also submit that the record makes clear that there was a dispute before that action was filed as to what the meaning of the documents meant. And so when you look at the add to decision and some of the other decisions we've cited in our briefing, the fact that there is a difference in subjective understanding of what the agreement means, or one party says it means X, the other means Y, does not create an ambiguity and does not open the door to admitting extrinsic evidence. The court is first charged with interpreting that agreement and determining whether it's ambiguous based on the four corners. That's what add to makes very clear.
Counsel, thank you very much.
Thank you.
Thanks to both counsel for your excellent arguments. I haven't heard Raffles versus Wickleshouse referred to since contracts class in 1972, so that was quite exciting. Thank you. The case will stand submitted and the opinion will issue in due course.